Good morning and welcome to the MHC In-House Masterclass for IP and Technology. Obviously this year it's coming from a more remote location given the circumstances, but we hope it's going to be as interactive as possible. You'll see a Q&A ability in the Zoom there, and please use it, and we'll get to questions towards the end. So what I'm going to deal with first is a sort of a roundup of IP cases that have happened over the last year or so, and I've picked a few themes through the various IP rights of trademarks, copyright and patents, and then Brian's going to deal with AI in specific contexts. So just looking at trademarks, I suppose I'm not going to dwell on COVID-19 and the issues that are there, but we have seen how it has impacted trademarks in particular around filings for trademarks and dealing with opposition. So the various trademark offices, be they in Ireland or in the EU or foreign field, they have extended all the deadlines at this point to the 18th of May. So it's given parties obviously time to deal with trademark issues. But one of the more recent and interesting developments around the COVID-19 situation is the sporting events. And we would have seen in the media the reluctance of the International Olympic Committee to delay in any way the Tokyo Olympic Games this year. And there are a variety of reasons for that, but one reason actually is the fact that a lot of work goes into preparing for a sporting event like that. There's a lot of trademarks that are filed around Tokyo 2020 to facilitate merchandising and the like, and to ensure that there are laws around ambush marketing. So that's why when the games do happen next year, they'll still be called Tokyo 2020. So all the merchandise and all the sponsorship that has been put in place will remain in place. UEFA have done something pretty similar in respect of the Euro soccer championships were going to take place partly in Dublin this year. But it does facilitate ambush marketing of sorts. Puma, for example, have filed Puma Tokyo 2021. So it'll be interesting to see how that does develop on the merchandising front. So some real impact that COVID-19 has had there. But I'm going to look at, from trademark perspective, some of the marks around colors and shapes, and to see how, again, these are being sort of looked at by the courts and by, obviously, trademark offices. And the Red Bull colors, the blue and silver, I think we're all familiar with it. We're familiar with the getup of the can. That has been registered as a trademark. But the colors scheme itself, what's seen on the slide is actually the representation that was in the application, but the description talked about the blue and the silver being juxtaposed together, and indeed a rough 50-50 split. It didn't actually say how it was to look. It could have been horizontal, vertical. It tried to claim all sorts of 50-50 splits and how it might be joined together. And for that reason, it was considered to be imprecise and couldn't be protected as a trademark. And underlying that is a reluctance on the part of trademark offices and indeed courts to allow a company to monopolize a particular color scheme. So it's possible in certain circumstances to get a trademark on post have a particular Pantone of green, for example, but there is a lot of resistance from courts and trademark offices to allow these applications, particularly on the grounds of being imprecise, as you'll see there. Another case around shapes, this is the Rubik's Cube, the best toy from the early 80s. I'm sure we're all familiar with it. Here again, the issue is whether it could be protected as a trademark. And that's very attractive because it's potentially an infinite protection if it's renewed every 10 years. Arguments were made that it should have been protected as a patent, but here they're obviously looking for a trademark. And what the court did here is it looked at the essential characteristics of the mark, be it the cube, the black lines, and indeed the different color squares on it, and assessed whether the black lines and the cubic shape, for example, are needed essentially for a technical result, which is one of the exclusions from trademark protection for shapes. And in this particular case, it was held that they were needed for that, and therefore there couldn't be trademark protection for the Rubik's Cube. Another example from UK courts is the Babybel cheese, the wax that goes around that. You'll see it was represented by a 3D mark, exactly as you see it on the slide, and it was looking for the color red. There was no Pantone defined or anything like that, simply that the mark was limited to the color red as seen, to the dimensions as seen on the picture there. And again, the court here held that it was too imprecise to try and claim all sorts of red and shades of red, and therefore the mark was not allowed and was invalid. Then looking at copyright, We've seen some developments on the legislative front. There was a recent act there on foot of the Copyright Review Committee was looking at, for instance, fair use they used to have in the States, to whether that should be over here, and whether we could in Ireland implement more defences in particular to our copyright law regime, which was put in place obviously in the 2000 Act. So there are now parody defences. It'll be interesting to see if they come up at all in practice, and other defences around educational and disability and things like that. But what I'm going to focus on is some of the case law around what is a work and what can be protected from a copyright perspective. We know from a Court of Justice decision in InfoPack that an 11-word string of words that comes up in a search term can be protected as a literary work for copyright purposes. We now know, based on the Pelham decision, that a 2-second musical clip can also be protected, notwithstanding it's quite short. So this case held there's protection there. Obviously, if there's a sampling that goes on and it's unrecognizable to the ear as it was originally recorded, there's no infringement. But here, if it's obviously the same clip, and even though it's 2 seconds, there is a protection there. Looking at how copyright has now, I suppose, evolved quite significantly in particular, is around the area of clothing. And this is something that's come up for quite some time, and maybe the laws in Europe deviate to some extent. And this COFEMEL decision has brought that back, I suppose, on a harmonized field. In Irish law and UK law in particular, there was a requirement for something to be an artistic work and have an artistic quality. So garments that you'd buy on the high street never actually qualified as works of artistic craftsmanship and the like. In Portuguese law, there's a similar aesthetic requirement. And the case here was taken by G-Star against imitative clothing. And it was argued that it should be copyright protected. And the Court of Justice agreed that it could be, because the requirement is one of originality, not one of artistic quality, for example. So what this has done is it's effectively opened up copyright infringement as a basis to pursue imitation clothing. In the past, one had to rely on things like design rights, which obviously are of limited duration if they're unregistered, or obviously if they're registered, they go on for a significant period of time. But if you didn't have design rights, you were left with not having copyright available, or indeed passing off, which has its own issues, and she'll talk about in a moment. So we've seen how, for example, in the UK courts, this case was subsequent to that, and it held that the fabric design of this particular garment could be protected by copyright. So it's certainly a shift from all the previous case law before the COFEMEL decision. Just finally on copyright, I'm looking at this Charlotte Tilbury makeup case, which has a starburst design on it. And this is a UK case, but effectively it had the starburst design on the case of the foundation powder palette, and indeed on the foundation powder itself. And Aldi had produced its own version, which was obviously quite inspired by the Charlotte Tilbury version. And the issue that came up before the court in particular was whether it was a copyright protected work, particularly as it was on the foundation itself. And the argument was made, because it was so temporary and it wasn't a permanent artistic work, it shouldn't be protected. That was Aldi's argument. Now the court disagreed with that and held that it didn't matter, that it was to some degree temporary. In other words, once the brush or the pad was put onto the palette, it would obviously wipe away. That was okay. The judge in the case argued that a cake, for example, could be an artistic work, but is ultimately perhaps eaten at some point, or a sand sculpture or something is washed away with the tide. So in the case, it held that there was copyright infringement, which was quite a good right to have, because here there was then infringement because a substantial part of the work was copied. If you had to rely on passing off, it would have been necessary for Charlotte Tilbury to argue that the public would have recognized that design as coming from Charlotte Tilbury, and therefore there was a misrepresentation when you bought it in Aldi. And there's a lot of conversation around that as to whether somebody going into Aldi would be confused as to whether they're buying the real product or not. There could have been, for example, a disclaimer at the point of sale or at the point of display. These things feed into a passing off argument, and therefore that's why copyright is much more attractive. So we'll probably see, based on the last few cases I've dealt with, an increase in copyright infringement claims coming through the courts. Then finally, on patents, the biggest and main development, certainly from an Irish law perspective, is in relation to preliminary or interlocutory injunctions and whether they should be granted prior to the trial of an action. And we've had, over the last couple of years, a number of cases around from the High Court as to whether damages would be an adequate remedy, particularly in the patent space, where you have, as a generic manufacturer, a sense that the product is invalid. You don't want to go through the whole case of invalidating before you launch. You're confident it is, and you could pay the damages, and therefore, why should you be injuncted? The High Court, for quite some time, had held that line, and therefore injunctions weren't being granted and weren't being sought in IP cases, and that had fed into trademark cases as well. But this case went to the Supreme Court on appeal. Interestingly, the right involved here was a supplementary protection certificate, a patent type right, which actually had expired, but the Supreme Court decided to hear the case anyway, because it was a significant issue of importance in respect of the legal issues that had surrounded the granting of interlocutory injunctions, not just obviously in IP cases. So here the court held that perhaps the test of serious questions to be tried, adequacy of damages, and balance of convenience probably got a little jaded through overuse through the courts and over interpretation through submission. And it was held that adequacy of damages is no longer the definitive factor to knock out an application. You still have to look at the thing in the round in accordance with the balance of convenience. And therefore, you could look at other factors, such as, are there cases in other European countries with similar results by way of validity of the IP right? For instance, did the generic manufacturer try to clear the way? Other issues come into the fray now, and that's probably a positive enough development. So I think we'll see probably more injunction applications going forward. Then we have a Court of Justice decision, which is a good indicator of what happens if you are injuncted prior to a trial, but it turns out you should never have been injuncted. And as we know, when somebody applies for an interlocutory injunction, they give a cross undertaking as the damages. So what happens and how is that compensation assessed? So this case looks at that in accordance with how the IP Enforcement Directive as an EU measure speaks to it. And it has to be a harmonized effect is what the Court of Justice is saying, but also the compensation should only really be paid if the application was unjustified. So some useful guidance there. So finally, and something which is going to feed into what Brian's going to talk about in a moment, is a development around AI, and in particular, 2 patent applications that the European Patents Office refused, one for an LED, light emitting diode, and the other for a food container. But the inventor was named an AI machine named Dabus. So effectively, it wasn't a human natural person who was named as the owner stroke inventor, but a machine. And the EPO, in a very short, I suppose, 16-minute deliberation, decided that this could not be a patent that could be granted because patents are a property right, which couldn't be owned by a machine. It has to be a natural person. But also the right to be named as an author is considered a moral right, which would belong to a person, a natural person. So this is an interesting development because obviously more and more things will be created through the AI functionality. And Brian, I think this is a great opportunity now for perhaps you to sort of step in and show how maybe at an EU level, the law is evolving in the area of AI.
Great, thanks very much, Jerry. Yeah, it's an interesting case, that that recent application, and as you say, it was shut down very quickly by the EPO, and there's a couple of reasons for that. One, it actually says in their rules the inventor needs to be a person, and also 2, there's been a lot of discourse about this at an EU level since about 2017, when the Parliament brought out a proposal on civil law rules for robotics. And it posed the question openly as to whether we should now be looking at the possibility of machines owning their own creations and machines having personality. Very, very quickly, that notion was shot down by a bunch of experts, and subsequently it's very much kind of taken a back seat. And the kind of, I suppose, understanding behind it all is that the machines and the capability of the machines right now, although they appear quite good and quite sophisticated to us, are still at the end of the day just algorithms. And to even be contemplating assigning some sort of legal personality to them is just not at all on the cards for the moment, and indeed for the near to long term. So if we maybe flick on to the next slide there. In my session in the next, say, 10 or 15 minutes, I'm just going to have a quick rundown on the latest updates on the regulation of AI in the EU, which has certainly taken a big step recently. And I'm also going to look at 2 case studies that we're working on in practice ourselves at the moment, to give you a sort of a flavor of the sorts of issues that AI is throwing up when it comes to the day-to-day job. If we could move on, thanks. The first one we're going to look at is the regulation of AI. And before we jump into what has happened recently at an EU level, it's worth maybe casting our minds back to, and maybe taking a step back also to see what the position is like on the world stage. Broadly speaking, there are 3 players: the EU, the US, and China China is very much to the fore when it comes to innovation in this space. Generally, kind of the kind of anecdotal reasons for this is that China's, I suppose, culture around the regulation of and harvesting of personal data is very different to ours, and they take a very, very different approach, and the culture seems to be quite adapted to maybe handing over and being part of a system where large amounts of your data can be processed in a very free and open manner by the state. You'll have seen evidence of that recently with the COVID commentary, where you'll have even seen drones hovering in the streets, identifying individuals and telling them to go home. The US is not anywhere near like China, but is, I suppose, in a sense, a little bit more aligned with the Chinese model than the EU model. The US model is kind of almost back to the early days of the startups with the kind of move fast and break things, where they're plowing ahead and doing as much as they possibly can in the area of AI, and they're investing a lot in it. There's light touch regulation. There was recently mooted legislation around specifically AI, but that's taken a back step. In the EU, it's very much a very, very different prospect. If we move on, please. The EU has taken a position that it wants to shape its approach to regulation and indeed investment in AI in a manner that they call trustworthy AI. And if you move on to the next slide. In my mind, this is a sort of a branding initiative. It's saying to that world stage of the EU, China, and the US that we're going to do things differently to you. We're going to do it in the sense that is aligned with, let's say, the overriding principles of the EU. With, you know, we were the first there with the privacy regulation in a great extent. And we are going to protect our citizens in how they deal with this type of technology. And we are going to make sure that when it's delivered to our citizens, it is done so in a trustworthy manner. So if we move on to the next slide. Here are the 7 principles that have been developed over the last 18 months by what is known as the high-level expert group, which was set up and tasked by the Commission to oversee and shape how we are going to regulate AI in the EU. They started out by producing ethics guidelines. They then moved on to policy recommendations. And the key, I suppose, tenets of what the regulation of AI will look like involve the 7 points on the screen there. And those of you who are kind of very involved in the area of GDPR will recognize some very strong influences in there around transparency, accountability, privacy, technical robustness, and safety. Additional things that are very AI-like are, you know, the human in the loop, or huge human agency and oversight, and diversity, non-bias, etc. And there's also an interesting one about, you know, the AI must take into account societal and environmental well-being. So you can see a very, very different approach here to the US and China, and to an extent it'll be our US neighbors who are investing in AI and selling AI products into the EU market are going to find this a particular challenge, I expect. So if we move on. The ethics guidelines and the policy recommendations were done by June of last year. Commission President von der Leyen, who took office in October, made it one of her key goals to oversee the development of AI in the EU. And that's not just from a regulation perspective, but also from an investment perspective. She sees this as a, you know, a key, I suppose, asset of the EU going into the future. She said that within her first 100 days of taking office, she would introduce legislation specific to AI. most of the people on that high-level expert group kind of raised their eyebrows at that. And lo and behold, by the time you got to February of this year, it wasn't legislation that was introduced, but a white paper. Nonetheless, this white paper is very interesting in that it sets out a number of guidelines for issues that need to be addressed, and also recommendations for how they should be addressed in regulation. And there's two other papers, companion papers published, one on liability specifically, a whole separate paper, and another one on data. And we'll take a look now on the next slide at an example of what is in the white paper from the perspective of an autonomous vehicle. And you see here that a particular issue being tackled again is the Product Liability Directive, and they're saying a manufacturer is liable for damage caused by a defective product. However, in the case of an AI-based system, such as autonomous cars, it may be difficult to prove that there is a defect in the product, the damage that has occurred, and the causal link between the two. In addition, there is some uncertainty about how and to what extent the directive applies in the case of certain types of defects. For example, if they result from a weakness in cybersecurity. In the round, what that's saying is that the Product Liability Directive is a key piece of legislation with regard to AI getting on the market, and it is not fit for purpose for this particular type of technology. So to kind of reflect back over that whole piece we're talking about there, is that legislation is coming. It's expected by the end of this year, but it was expected by the end of this year before COVID. So I'm not so sure if it will actually be seen by then. There should be no reason why it cannot be, because that high-level expert group is working away in the background and is working remotely anyway. Maybe it will be a funding thing, but as things stand, that white paper is open to public consultation until the 31st of May, and really any manufacturer or supplier in this space, I think anyway, needs to be engaging with this process now, because you can see that the approach being taken by the Commission is very different to the US. And if, I suppose, influence needs to be brought to bear, now is the time to be doing it. And the process for contributing to commentary on that white paper is quite a simple one. It's a questionnaire and available on the AI Alliance website. Okay, if we move on now to some of the requirements here regarding the implementation of the legislation. And these are the sort of things that manufacturers and suppliers are going to need to take into account or anticipated that they will take into account when the legislation is introduced. So the system has to be trained on data sets that are sufficiently broad. They have to maintain accurate records regarding the training data set. They also have to give information to users about when they're interacting with AI. And this is a very simple example of this would be, we're all used to dealing with chatbots on websites at this stage, but when things get more sophisticated, they will want it to be the case that the AI will identify itself at the outset as AI and not a human. And also when the AI is giving or a decision or a result, they want the capability for human intervention at various different points, I suppose, depending on the type of AI involved. So you can see that there's some very new and onerous provisions that could be coming in. No guarantee just yet, but it's certainly a space that everybody who is, I suppose, manufacturing or developing in this space needs to get into. Next then, I'm going to look at two case studies. And both relate to, I suppose, dealing with AI in the context of our work on a daily basis. The first of these is a very interesting one, which you'll probably see more of, is the intersection of AI, IP, and privacy. In this particular example, we have a client that has a core business in the collection and processing of personal data. And some of this is done by machine learning and AI. And the type of personal data I'm talking about here is not name, address, email. I'm talking about sophisticated derived data from the personal data, and that is done by machine learning and AI, not in all cases, but in many cases. And these produce data points for the company, which are very useful, but also because of the nature of those data points, they're still classed as data related to an individual, so they're personal data. So from the perspective of the client, what you have here are trade secrets and IP that are very, very valuable to the company. And now you have an interaction or a kind of a conflict between privacy law and IP law, where the data subjects, rightfully so, are making many data subject access requests, and across the business, this is a very significant number. And the client wants to be GDPR compliant and is GDPR compliant and wishes to disclose everything they possibly can in accordance with GDPR. The trouble is that if they start disclosing absolutely every single aspect of the data points, it could result in erosion of their IP. So they came to us to kind of notionally go through a project to see if there's any means by which they could protect this IP. And there is indeed under GDPR Article 15.4 and Recital 63.5, which essentially sets out a derogation from handing over personal data if you can demonstrate that that disclosure will adversely impact on your intellectual property rights. The reason we're talking about trade secrets is because trade secrets, and you're going to see this come to the fore in the next couple of years, they are the IP right that will protect things like AI and machine learning, perhaps more than others. Because of the nature of AI, it tends to fall in between stools around copyright and patents, trade secrets, and with the advent of the recent trade secrets legislation from the EU in the last couple of years, are actually quite a useful tool, and you're going to see a lot more people using that. Traditional database rights, and indeed the sui generis database right, are actually applicable as well. But beware a commission view, just a view, not the law, given in the last couple of years, that IoT generated data and AI generated data in the view of the commission is kind of bulk generated data and should not qualify for the sui generis database right. So people operating in this space, I think, need to get their heads around some of these IP rights that traditionally weren't necessarily to the fore, but now may be used and deployed in this way. Just like Jerry's example of copyright with the change in law. On to the next one. This particular case study involves work we're doing with an AI developer client of ours, and they are developing a bespoke machine learning and AI tool for a bank in the US. This US bank has a very large portfolio of loans, and the client's tool is quite sophisticated in that it can get in there to the data, structure it from being absolute mess, structure it, and then manipulate it and deal in the data in a very efficient and precise and accurate manner. And it's said that the sort of, I suppose, advantages for the US bank in this case is that it's cutting lead times on some processes from 18 days down to 3. So it's a significant gain for the US client. The interesting points from our perspective are how these sort of development agreements are not the same as traditional IP development agreements, which would be, you know, piece of IP developed, be it software or something for a client and given to the client either on-prem or remotely. In this case, what you're doing is you're taking a fairly sophisticated AI engine and you're going to bring it on to the client's system and you're going to further train it to their requirements using data sets provided by the client. So if you like, you're going to improve your existing IP based on data and materials and documents provided by the client. So there's two aspects to that. One, the quality of the data they're giving you, and two, you're improving your IP. That brings to light all sorts of impacts on traditional sets of warranties that you give in these sort of development agreements, and also the IPR infringement indemnity and the extent to which you will give it. So if you're acting for the developer, you're going to want different sort of caps and exclusions. And if you're acting for the customer, you're going to still want to push for as much as possible. The data piece then also impacts the engine of the client in that the data used the data used to train the engine, particularly for the client's system, will leave imprint or an impact on your engine as the developer. And as a developer, you're walking away from the project with like all the projects you will do, with a slightly tweaked engine based on somebody else's data and materials and documents. So you need to understand how you will treat that in the contract and what sort of licenses or acknowledgements you need with regard to using that post termination or expiry of the arrangement. So I think if we move on then to kind of recap with regard to the legislation piece, It's moving a lot quicker now, and it's at the point where people who manufacture and supply AI tools need to be getting their head into the thinking of the EU on this particular area, because it's quite different, and need to start interacting with how they're doing it to try to shape that legislation. What we've learned, our key takeaways from some projects we're working on, is that trade secrets are a fantastic means for protecting AI-based systems, and also the interaction between privacy law and IP law is now becoming a kind of a new area where we'll be dealing in. And then finally, when it comes to doing development agreements with customers for AI engines, do not stray into the thinking of treating them exactly like traditional development IP agreements. A little bit of a more nuanced approach is required. Thanks very much.
Thanks, Brian. I think we just see if there are any questions there. Through, how difficult would it be to trademark the words COVID-19 or coronavirus? I suppose that's an interesting one in the sense that, well, if somebody wanted it, I suppose you wouldn't put it on foodstuffs or disinfectant. But I think there you'd see a public policy objection to those words being monopolized, etc., through a trademark application. So I don't think there would be much prospect of sort of that happening.
Right. Yeah, I think I see one there around who is to blame if an autonomous vehicle crashes. That's an interesting one, and it comes up quite a lot. And it goes into, this recent white paper goes into this in some detail. And I think what you need to consider is the number of actors. When I mean actors, I mean suppliers and product suppliers in an autonomous vehicle. I mean, the difference between an autonomous vehicle and one from, let's say, the year 2000 is they're worlds apart. You know, at the high end of autonomous vehicles, or just even at the high end of vehicles on the road today, there are many of them that can literally drive themselves once they get on the motorway, and they need little or no input from the driver. There is a requirement that the driver has to at all times be in control and have their hands on the wheel. But I have seen numerous kind of YouTube examples of certain luxury vehicles on the road in Ireland and the UK that have perfect capability to stay in lane. They do that by being stacked to the brim with sensors. And all those sensors are not produced by the traditional car manufacturers. They're bought in and they're put into the supply chain of the car. So you have a whole bunch of actors in that particular vehicle. Then you got to take that vehicle and put it on the road, and it acts with a whole bunch of other systems, you know, networks and other sensors, so that it can stay away from the car in front of it. It can understand its position on the road. So you can think that in the case of a car crashing on a motorway, an autonomous vehicle crashing on the motorway, there's numerous actors that could be pointed to for the purposes of liability. And the product liability directive, with its strict liability for the manufacturer, is really not fit for that particular purpose. And I think that's why you're seeing this legislation coming to the fore at an EU level, and why we will see a very different approach to how to deal with liability in the next year or so.
Okay, I see another one about, could copyright and design be applied to labels of food, drink, cleaning products that we see certain discounters imitating? I suppose the answer to that is yes. Obviously, there is that phenomenon of copycat packaging, packaging that actually winks at maybe a household renowned brand. The issue there is whether there is a sufficient copying of what we call the label being an artistic work. Often, you know, simply using the same color scheme, perhaps with different words and things like that, mightn't qualify. So it's accepted, I suppose, in that industry that there's a lot of imitation packaging that might live quite dangerously to the packaging on the, let's say, better known brand. And it's really a question of confidence then as to how close it is, and whether the known brand would feel that they could convince a court that there's been sufficient part of that artistic label work copied. It's definitely something that has certain companies scratching their heads all right, and quite frustrated, but it just seems sometimes they are on probably the right side of it, and that's it. I
see a couple of queries in there around legal personality and AI machines, and I suppose who's to blame if an AI machine infringes your patent. Just to maybe go into a little bit more in depth as to what the AI personality test might look like. In 2017, I think it was, those Parliament Civil Law Rules on Robotics offered the question as to whether there should be personality. It was a whole bunch of experts from legal backgrounds wrote an open letter to the Parliament and said you should not even be thinking about this, because to try to ascribe some level of personality to a machine that is not at all sophisticated just kind of misses the point in the first instance, in that these machines aren't sophisticated enough for even us to start having the conversation about whether they should have AI personality or not. And then they also, on top of that, dismissed the concept of creating a new type of legal personality for these machines on ethical grounds. So there's strong resistance, and the expectation of us seeing anything like personality for AI machines in the next 20, 30 years is very, very low. The expectation for the type of intelligence that is required to maybe mirror or come anywhere near human intelligence is, experts vary, but they say, some of them say 40 years, some of them say 100 years. It's very far off. There's legislation existing on the books in Ireland and the UK under the Copyright Act, which does deal with computer generated work, which is work not generated by an author. And in that case, it designates that the author of that computer generated work are the group of people or the person that put together the arrangements necessary for the machine in the first instance. That in of itself has not yet been tested by the courts as far as I'm aware. And you can see how even the loose definition of, arrangements necessary for the machine itself could be a very, I suppose, hotly contested area. So I expect that if we're going to see any legislation, any case law around issues of legal personality with machines, it will first hone in on that Irish and UK case law about computer generated works. I
think, Brian, there's a few more there on the AI front. You might deal with those.
Yeah, see one there about has the EU measures been supportive of and facilitated the development of AI, or have they caused the EU to fall behind the USA and Asia? The key criticism a lot of people have of the EU, apart from the standard thing of there's way too much regulation in the EU, is that the EU is simply not pouring enough money into AI. There's a lot of talk in the EU about wanting to make it a key pillar of what we're going to do as a bloc into the future. But there's an issue with the amount of investment being poured in. There's also an issue with the kind of segmented or siloed approach of many member states, and they want to pull it together now as a bloc approach. I think anyone who is going to keep hammering away at the regulation piece is going to find themselves falling on deaf ears. There's a very defined view across the EU that it will fall in line with the type of process that was GDPR, in that the consumer will be put to the center of the issue, and the consumer will be the one that's supported. And if we, I suppose, try to take maybe a kind of an Asia view of it, it just won't run here. So for me, it's more of a management and investment piece at the moment is the issue.
Yeah, I see a question. It's a Brexit question. Actually, I haven't heard that word in quite some time. But is there any action that holders of EU trademarks should take before the end of 2020 in order to ensure protection for their marks in the UK? That is a difficult one, because it really depends on what the relationship between the UK and the EU will look like after the end of 2020. Obviously, the COVID-19 has perhaps put a little slowdown on the negotiation, but what should happen if there's a deal, a proper deal, is that any EU marks should automatically become a UK national right as well. Where you get into a grey area is if you have an application for an EU mark at the moment, and that doesn't actually go through to registration prior to, let's say, the end of the year, if there's a no deal scenario in particular. So what we would advise clients, and we are advising clients at the moment, is that certainly from here, that if they're applying for an EU mark at this point, they should also look at applying for a UK mark. Otherwise, if they've applied for an EU mark, it should probably be registered by the end of the year, and hopefully if it's property that goes through, will be protected automatically as a UK right too. Brian, there's probably one more.
Yeah, there's one there. You may have covered this, but how do you draft licensing terms for AI deployed to clients where the learning that improves the utility of the AI is derived from the use of the client IP? Yeah, it is to an extent. I touched a little bit about that on the talk, and it is a very, very important area in that the documentation and data being provided to you by the client certainly improves and also changes the nature of your machine. You're doing it specifically for that client, but you are also very much aware that it is in some way, well, I suppose depending on the quality of the data, it's certainly in some way improving your own machine. And then from the developer's perspective, you need to look at how do you approach the right to use that data, or whether it's actually required. I mean, once it's imprinted on the machine, maybe you don't need a right to use it. But maybe you do need some sort of an acknowledgement or a right to use that client's data in perpetuity if you wish to use that learning with other parties. But then it also impacts on the extent to which you're comfortable giving warranties over the machine, or you're comfortable giving an IPR infringement indemnity, and the extent to which you need to look at exclusions around warranties and indemnities. And as I was saying in the talk, it's not that there's a massive shift with regard to a traditional IP development agreement. It's more, it's a nuanced approach, and it needs to reflect the type of technology you're using, and it is certainly not the same as how we would traditionally draft those agreements.
I see AI is a very popular concept here. Brian, maybe you just take one more, and we're coming close to time there on the AI front.
Sure. I think I see one there on GDPR. It says this exclusion under GDPR, recital 63 in Article 15 is about access. Do you think it would really stand up as a reason to either not confirm processing or provide a copy of the personal data? I don't know is the answer. The project we're working through at the moment is looking at a number of grounds with regard to the protection of the client's intellectual property. The extent to which it will stand up, you know, we have our own views on the varying strengths of the arguments going across the gamut of trade secrets to database rights to sui generis database rights, and we've done that analysis. Some stand up better than others, but ultimately it'll be when, you know, that argument is used, whether it will actually stand up.
Okay, thanks. I think we're coming up to the 45-minute slot there. So thanks very much for everyone participating. Obviously, there's a recording of this which will be circulated, so you'll have a copy of the webinar should you need it. Also, we'll be sending through a survey, and we'd appreciate if you'd have a look at that. And in particular, if you could indicate any topics that you would like MHC to deal with as in a webinar, we'd be very happy to sort of look at facilitating that as well. So thank you very much.
Thank you.